Hi there, I'm David Himelfarb, Managing Partner of Himelfarb Proszanski, Personal Injury Lawyers. I've been asked to put together a lecture on medical-legal approach to successful disability claims for physicians. The objectives today, speaking to a group of family physicians, is to help your patients get the disability coverage that they deserve, help you get compensation that you deserve, keep insurance companies off your back, because as a busy general practitioner, a busy family doctor, you don't need to be answering questions from insurance companies all the time. And to challenge each one of you in the room to think about a patient who you have under your care who can benefit from this lecture today. So who we are. We're Himelfarb Proszanski, personal injury lawyers. We're successful, well-respected personal injury law firm specializing in personal injury and disability claims. We have 100+ years of experience settling and trying cases. And we have a proven track record of successes. We've settled well over 3,000 cases, and we have settled about $1 billion plus of settlements. We're located in downtown Toronto, steps away from the courts, and conveniently located right at the St. Patrick subway station. Excuse me. Let's talk about disability and statutory accident benefits. In auto cases, where someone's injured in an auto accident, Ontario's standard auto insurance policy provides no-fault benefits to those people that are injured, regardless of who's at fault. Those benefits are defined by a regulation called the Statutory Accident Benefits Schedule, or the SABS. It's a regulation under the Ontario Insurance Act. And those who are not eligible, in completing a disability certificate, which is essentially a medical report for someone who claims that they've been injured as a result of an auto accident and are most likely looking for some form of a disability benefit, one should state the cause and nature of the injuries, estimate the duration of disability and treatment, address any pre-existing conditions that may complicate the recovery, and include associated psychological issues such as stress, depression, and disturbed sleep. Submit the updated OCF3 forms to include additional compelling evidence as the claim evolves. Keep a copy of the completed OCF3s that you've completed for your patients in the patient file. And you can find the OCF3 forms online, and we've provided you with the address on the web to go get it. There are professional service guidelines in terms of how much a family physician can charge for filling out a disability certificate, and you'll see that the maximum payable is $200 currently, set by the Financial Services Commission of Ontario. There's something in the regulation which is called the minor injury, or the minor injury guideline, which is called the MIG. And basically it states that if a person sustains an injury that is predominantly minor, that they are limited to a maximum of only $3,500 in medical and rehab benefits. They're not eligible for any attendant care benefits. They would still be eligible for income replacement if they met the disability test in the Statutory Accident Benefits Schedule. But there is a significant reduction from $50,000 of medical rehab coverage down to $3,500 if you're a minor injury. What's the definition of minor injury? It's a sprain, strain, whiplash-associated disorder, contusion, abrasion, laceration, or subluxation, or any clinically associated sequelae. It's thought that this definition includes such serious injuries such as a partial tear of an anterior cruciate ligament, for example. So it does include partial tears of tendons and ligaments, which means that you may be treating someone who has, for instance, a partial tear of a rotator cuff in their shoulder. They may be a laborer. They may not be, and it may be in their dominant arm, they may not be able to use their arm or hand function. They may be significantly disabled, and yet the definition under the MIG would say that they have a minor injury and only available $3,500 of treatment. Now, the claimant could be exempt if the injury is minor, but based on compelling evidence, they have a pre-existing medical condition that will prevent them from maximal medical recovery if the $3,500 limit is imposed. So what does that mean? So say we have someone who has a whiplash-associated disorder. It's a whiplash, bad back, bad neck. It's considered to be minor. But say that person has arthritis in the low back, diagnosed before the car accident occurs. That person now has compelling evidence that they have a pre-existing condition, the arthritis, which will prevent them from recovering properly with only $3,500 of treatment. We know that it's going to take a lot longer for that person to recover, and they'll need some more money than the $3,500 available. In that case, it's up to the family physician to identify that to the insurance company. Now, Financial Services Commission of Ontario's expectation was that about 40% of all claims would fall under the MIG. It's relatively new still. It's been in for a few years, and there are not many cases decided under the MIG. However, there is a case called Scarlett versus Bel Air Insurance Company. This is a Financial Services Commission arbitration case, and it basically says that it's the insurance company that bears the onus to prove that the person is falling within the minor injury guideline. And compelling evidence is based on the usual civil burden and needs to be credible and convincing. And the totality of injuries ought to be considered. Look at the constellation of injuries, even where soft tissue injuries are also present. And the determination of entitlement to treatment beyond the MIG is fluid and subject to revision, and hence the need to submit forms on an ongoing basis. There's 5 key points that I'd like you to consider. Number 1, words matter when you're completing the disability certificate. So if you believe that there's a serious injury there, you need to make sure that the insurance company understands what you're treating in your patient room. Consider any pre-existing conditions or associated psychological issues when completing the forms. And if you have objective testing that's been done, such as radiological testing, X-ray, ultrasound, MRI, CT scan, that shows something that may explain why your patient is having problems, please identify that. It's very important. Look at the totality of injuries suffered by your patient. Consider the requirement of compelling evidence when considering the forms. Look for pre-existing conditions, psychological issues, and refer to objective diagnostics. And ensure that you do get paid for the forms that you're submitting. You are entitled to charge up to $200. And my firm can help. How? How do we help? Well, we can help when there are 5 criteria met. So your patient is having a difficult time working. There's an impairment that's affecting someone's function to work, function to carry on a normal life, function to be productive, anything that's affecting function. The patient has access to a disability policy, such as a long-term disability policy, and a diagnostic test like an ultrasound or MRI reveals a cause of impairment, or the insurance company is just flat out refusing to pay for treatment or income. In those situations, we can certainly help your patient base. There are things in terms of a long-term disability claim for you to consider. These are claims where your patients will come in, they'll have group benefits or their own disability policy, and they'll bring in a form called an attending physician statement for you to fill in and identify to the insurance company what is wrong and what the duration of your disability is to be expected. So there's 4 components: the insurance company, the patient, the family physician, and then the lawyer. The insurance company is solely motivated by their bottom line. They will be actively looking for any and all opportunities to deny a claim, and that's why it's critical that we do it right the first time. The patient The patient is going to bring in a form, as I mentioned, the attending physician's statement, and it provides the basic framework for their claim. It identifies what their problems are. It has to be completed to apply for short-term and long-term disability benefits. The family physician has to complete the attending physician's statement for disability. It's very time sensitive, and it is the most important submission. It determines if the patient's going to be eligible for disability benefits, so extremely important. Use the form to provide information that's supportive of your patient's claim and, where possible, to advocate on your patient's behalf. And remember that the system is set up to facilitate a denial of claims. The forms really are not that user-friendly, and the forms are structured to elicit information that may not be helpful to or supportive of your patient's claim. Be proactive in referring your patient to specialists to determine what's at the heart of their disability if you can't find that out. The insurance company will seek an opportunity to discount the opinion of the treating physician, that's the general physician, the GP, where it extends beyond their area of expertise. So if there's an orthopedic issue, the insurance companies don't really want to hear from the family physician. They want to know, well, have you seen an orthopedic surgeon? And what does the orthopedic surgeon have to say about that? It's critical to understand the nature of your patient's employment. So you need to understand what is it that they do and speak to them about the type of employment that they are involved in and the specific tasks that they do on a regular basis, so that you can identify whether the physical demands associated with the employment are something that your patient is capable of doing or not. Please use clear language when addressing the impact of your patient's condition and their ability to perform employment duties. And always make sure that there's a diagnosis and prognosis, and refer, as I mentioned before, to objective testing where you have that. Now, there's two stages to a disability claim. In the long-term disability policy, there's the insurance company will pay the patient for usually 2 years if they can't do their own job that they were doing at the time that they became disabled. And thereafter, after the 2 years, they will only pay if the patient, is precluded from carrying on any occupation for which they're reasonably suited by virtue of their education, training, and experience. So those are the two stages of the disability claim. They're two different tests, and you'll need to understand those tests. So the test for total disability is not whether the patient has an absolute inability to do anything related to the previous occupation, but whether common care and prudence prevents them from engaging in those duties. Consider an example of a right-hand dominant orthopedic surgeon who sustains a fracture to their left pinky finger. In that situation, it doesn't seem so serious, but when you think about it, would you like to have an orthopedic surgeon who can't use the left hand, who has to use the left hand throughout the day in doing surgery and performing job function? That doctor might be not only not able to do the job, but maybe a security, safety concern. Do not look at what abilities the patient has been able to retain, look at what they've lost. And then evaluate the impact of those lost abilities on their ability to carry out normal and regular duties of employment. Determine if the patient is capable of sustaining duties on a consistent and regular basis. If not, then they're not going to be able to go to work. They're disabled. Now, the last person is the lawyer in the four people that we were talking about, the four areas. The lawyer is going to reduce the number of times the patient comes to your office with paperwork, allowing you to spend your time focusing more on patient care. The lawyer is going to help you complete your paperwork effectively the first time to minimize ongoing demands from the insurance company. They'll manage forms to ensure the best medical evidence is put forward and ensure that compensation for your work, in other words, your forms and reports that you submit, that they get paid. And provide you with peace of mind and help you and your patient navigate the legal system. Just remember, we're always a phone call away and we can help. And together, we can make a difference for your patient. Let's talk about 5 key points that we would like you to take from our presentation today. Ensure thorough and accurate completion of the attending physician statement and all your subsequent paperwork to the insurance company. Cannot stress that enough. Understand the nature of your patient's employment, specific duties and tasks. Take the time to sit down and understand what the job is specifically, not just an overall sort of general understanding. Understand the definition of total disability and the own occupation versus the any occupation clauses. And remember, the system is set up to facilitate a denial of claims. It's critical that we should be doing it right the first time. You certainly owe it to your patients. And again, we can help when any of the following 5 are met. The patient is having a hard time working. There's an impairment that's affecting function. The patient has access to an LTD policy. A diagnostic test like an ultrasound or MRI reveals a cause of the impairment. The insurance company refuses to pay for treatment and or income. I want to thank you for coming and listening to our seminar today, A Medico-Legal Approach to Successful Disability Claims for Physicians, and thank you for listening.